Appreciate your solicitude for the petitions that we might get in the future, but you talked about speculation. That's speculative, and I did not hear Mr. Francisco say that he has a plan to attack other provisions. Maybe he does. Maybe it's predictable that he would, but
he said
we have one provision before us today, right? So don't we have to decide this case and not speculate about what might come later?
Two things. I think he said, don't be blind to reality. Let's not be blind to reality. Their own brief reiterates their opposition to the contribution limit, expenditure limit. It reiterates their opposition to Buckley. But you asked, Your Honor, Justice Alito, don't we have to do this? No, you don't have to do it. And the reason you don't have to do it is because this case is a walking vehicle problem. Let's imagine we had a time machine and we went back to June.
All right, well, let's talk about the vehicle problem and let's talk about reality. At what point you have a vice president or even a sitting president who has been in, may or may not run for a second term, that potential candidate, at what point do you think that potential candidate would have be able to challenge a provision like this? And here it's not a question of standing from the outset. It's a question of whether it has been shown that the case has become moot.
Right. So I think the analytical question to ask is, does the candidate still have a concrete plan to run? And I think the evidence might not be.
And you would say only when the candidate has a big event and announces, I'm going to run, even if the candidate has raised a lot of money and has hired all sorts of consultants and.
No, Your Honor. I'm not requiring that. What I'm saying is that the analytical question is, when does he have a concrete plan? And then you're going to have to look to evidence in the public, in the record, et cetera, about what that plan is. And I think in a circumstance, I'll tell you when it's not satisfied. It's not satisfied when the candidate says, in comments published today, that a 2028 run is, quote, something that could happen, it's something that might not happen. Look at the other comments. In February,
isn't that what potential candidates always say? Until the day when they make the announcement. That's what they always say.
That's what candidates say when they're running. That's also what candidates say when they're not running. The most closely analogous candidate to the vice president, the most recent vice president who was serving a second-term president was Vice President Biden in 2013. He was saying virtually identical things to what Vice President Vance is saying now, and of course he did not run. So I think politicians, we all have seen politicians, they have an interest in not saying what their decision is until they have to, because it keeps their name in the news. I think here, but I think that this poses a really interesting and important question for the court, which is, are you going to be in the business of second-guessing the public statements of politicians and plaintiffs when they're telling you essentially that they don't have standing or that their case has become moot? I mean, Vice President Vance's lawyers are basically telling you, ignore what he's saying publicly. Don't believe him. Wink, wink, nod, nod. Don't be naive. We all know he's really running. If that were true, the easiest thing in the world would be for this plaintiff, like any other plaintiff, could have come forward and said, I'm running, or told his lawyers, put that in the brief, say I'm running, say I have a concrete plan. I understand why.
You're serious, but anyway, my time is up.
I'm serious, Your Honor. I'm serious that the same rules have to apply to all plaintiffs. And the fact that someone is a politician who has an interest in perhaps dissembling to the public about their plans is not a reason to relax your normal Article III standards. If the plaintiff in Lujan had come to you and said, well, you know, I did have a plan to visit the wildlife refuge to see the spotted owl, and I'd bought plane tickets and all that, but now I'm not so sure. I canceled the plane tickets. The plan is kind of off, but I might do it, I might not do it. It's premature to know. Any other plaintiff who was saying the same things that the Vice President is saying here, you would say there's no standing, and you would say that the case has become moot. And I think the same rules should apply to everyone.
Thank you, counsel. I want to follow up on Justice Kavanaugh's question at the outset, because I'm not sure it was answered directly, but is there any part of or language in McCutcheon with which you disagree?
I do think that there are concerns I have about the empirical analysis and the predictions that were made in McCutcheon in this analysis of joint fundraising. So if I could just sort of spell that out. I think the court in McCutcheon was responding to a hypothetical that the district court had put forward and certain arguments that had been made by the parties. And the court essentially said, it's just illogical, it's unrealistic to think that all this money is going to shift around in the way that's being suggested. And I think the court's opinion said something like, it's crazy to think that the Iowa Republican Party is going to want to help the Senate candidate from California and send the money to the California Republican Party. And I think that's true insofar as it's limited. It's true that state parties don't often shift to another state Republican Party, but the reality is that what they do, and this is just 100% objective fact that anyone could see if you go to the FEC website, is state parties don't give to each other. What they do is they send their money up to the NRSC, to the NRCC, and to the RNC. So just in 2024, for example, state parties sent almost $30 million that they collected, and they sent it to the NRSC. And they didn't do it because those states had Senate races and they wanted the NRSC's help. I mean, I'm talking about the Republican Party of DC, the Republican Party of Georgia, the Republican Party of New Hampshire, state parties that had no geographic interest in a Senate race. They sent that money up. In the presidential races, it's even more obvious. So there have been FEC proceedings looking at the joint fundraising campaigns of the Trump and Clinton campaigns from 2016. If you look at the money that the state parties received through those joint fundraising efforts, 80% of the money that Democratic state parties collected went to the DNC. 90% plus of the money that the Republicans collected went to the RNC. So I think in McCutcheon, probably because this wasn't properly put before you, but the hypothetical was not the exact hypothetical that needed to be considered. And so if the question is, are these state parties being used essentially as cash cows to kind of launder money through and get it back up to the national parties? The answer is absolutely yes. And that raises the very serious problems of quid pro quo corruption that I think we should all be worried about.
Thank you.